The following is a live broadcast of a Lone Star community radio program, recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and facebook.com/irlonestar. For more information on this show, please visit our show page at irlonestar.com/shows. To sponsor or donate to this program, visit our donate page at irlonestar.com/donate, or email us at lscrstudios@gmail.com, or give us a call at 936-666-1084. Lone Star Community Radio production and broadcast is possible by folks like you. So sponsor and donate today.
Hey, this is Chris from the Ticket Stub. You're listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe, and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony and Cheryl. Tony Lynn Collins and Cheryl Ellsworth Jahani. We are two Texas licensed attorneys, and we're here every Tuesday from 12 to 1 p.m. on 104.5 and 106.1 FM in Montgomery County. Conroe's FM is what we call the station, and we're proud of that. And also, you can watch us live on Facebook right now if you want. We are going to finish our discussion today on Second Amendment rights, stand your ground
Castle
doctrine.
Mm-hmm.
And those are used interchangeably. It's stand your ground, castle doctrine. It's the same thing. And then homeowners associations and how they can curtail your Second Amendment
your
rights.
ability
I think
to protect yourself, and not owning arms, but being able to protect yourself with any kind of to protect your property, whether it be firearms or whatever. And the reason that we've segued into homeowners association is because this came up recently in my homeowner association that we had an attempted robbery where some people during this whole riots and threats and all that stuff came into our neighborhood and followed one of our neighbors.
So it was after the George Floyd thing started?
Just right after that, right. And the St. Louis couple, the same, all this is kind of occurring. And then some people that didn't live in our area came down and followed one of our neighbors into their property, a gated property, but it was open. And it's an open.
You mean their gates were open?
Their gates were open because they'd just driven in.
Okay.
So they followed them in with their car. And of course, that's even worse because now you've locked if it closes automatically like ours does, now they're locked in too. It looks like they're supposed to be there. And so they put up large no trespass signs on their gates. And this is a mansion. I mean, it's a mansion with it would be like putting one up in River Oaks, right? And so the homeowners association is griping about it. And of course, I'm not directly involved with it, but in our Zoom meetings, it's come up with a lot of people that live around them saying we want those down. But then the silent, I think, majority, it would say, let them leave them up. They need protection. That's ridiculous. And so it kind of the argument, I looked into it, is can they keep those no trespass signs up? And many homeowners associations have regulations in their covenants, or a covenant that prohibits signs except for sale signs of a certain size, political signs during a certain period, maybe they have whatever the covenants are. Most of them they specifically tell you can only have certain signs and no other ones. And that kind of goes to what I think, not if somebody gets kind of crazy like a hillbilly and wants to put 5,000 no trespass signs up and they're big and offensive or whatever. Well, you can't do that. But if you were allowed to have a small one, then you would be allowed to have the other ones if there's no regulation on those. So that was the question we had: is there no trespass sign which serves the exact purpose that it's intended? Is it something that the homeowner association can enforce? And
you mean like take your signs down?
Yeah, or you're going to have, we're going to sue you basically if you don't take it down, because some of the homeowners, the ones that are vocal that show up, don't like the signs up, whereas a lot of people that aren't showing up are in complete agreement. So you've got kind of almost like you have right now in politics. A lot of people don't want to say anything because they're afraid if they say anything at all that detrimental to the bullies that are raiding and looting and all that, that they're going to be raided and looted. So they're keeping quiet, and that's not fair either. And so after looking into it, and we'll go over this a little bit today, I'm thinking that we might want to, when we have Representative Toth on or various other representatives we have visit with us, that we ask them about, maybe proposing a statute that allows for a small trespass sign for the very reason that we're going to go over today. And so tell us a little bit about Stand Your Ground to recap briefly.
Stand your ground, Second Amendment rights is the right to bear arms. Stand your ground is that you do not have a duty to retreat, to safely retreat. If someone busts in your front door, or I believe it's even on your property, but mainly I'm always thinking about the house. Right.
It's depending on the reasonableness of the force that because in Texas you can use force if somebody trespasses on your property.
Right. But you don't have a duty to retreat. And, to me, when I think about, okay, so just to complete that, you don't have a duty to retreat if someone trespasses on your property, and you can use deadly force
and
if
I always
you
have
think.
to look to see the actual law and the rules on that because it's so specific. The burden is on the person that uses the force against the person that came onto their property.
Right.
And you would think that's wrong. Somebody comes onto your property, that the burden shouldn't be on this should be on them. You came on my property and you didn't call first. You didn't. But could be an emergency. Could be one of your kids. They didn't know. Maybe they thought they had permission. Maybe they were just lost. There's a lot of reasons why they could have, and that's why they have the standard, the reasonableness standard that the burden is going to be on the person that may injure the party that you were using force against to get off your property, right?
Right.
And for the life of me, I don't have that right in front of me. But, here it is. Texas so-called Stand Your Ground laws allows people to use deadly force against someone else if they feel they're in danger. Conversely, it prohibits an individual from arguing self-defense if they provoked a threat from someone else to come to the property. So that could happen, too.
So what did that just say?
It's the flip side of it. If someone comes onto your property, and you see this at all these murder mysteries.
You mean like if I was fighting with you out in the street and I called you bad names and you followed me?
I'm thinking more in line with a family dispute. You're estranged. You have to pick the kids up or come over to my property because we need to exchange some stuff. Or I want to make up with you. Let's come talk to me, whatever. But there's a dispute between husband and wife, brother, sister, whoever, and somebody has left and they call up and say come back on.
Okay.
But they don't live there. That they're estranged, or maybe it's just you're visiting two brothers or something, whatever it may be, which happens in probate cases a lot. You have brothers and siblings that
Fighting.
are going to the family, the deceased house, because one wants to be the executor and one doesn't, and then you've got them acting like Texans pulling guns and stuff. It's just the craziest thing. But you can't invite somebody over and then use deadly force if you know they're coming over with a gun because they always carry one, and then say, oh, he pulled his gun on me and had enough time to, or you can't put it in their hand. You can't, as I say, it prohibits an individual from arguing self-defense if they provoke the threat.
Right.
So you can't be arguing with each other and then, pull a gun on them and then they pull a gun on you and then you're the one that gets hurt. It doesn't work like that.
Right.
The stand your ground is exactly what it pretty much says. You're going to stand your ground if somebody comes onto your property to be malicious, to rob you, to hurt you, to rape you, whatever. And then you have a right to protect yourself, but you still got the burden if you hurt somebody, kill them, maim them if they come onto your property, and you injure them. But then there has to be an injury too. So it's kind of tit for tat, and but the reason we're saying this is it's really important that if you are a homeowner, car owner, that you be reasonable in how you behave and you act.
That's right.
Because you may end up in court and may lose, even if you were reasonable, depending on how the facts are presented. And that we see that all the time with the St. Louis couple, with the George Floyd riots and all that stuff. So that's why this even came up. And in this climate is what happened. It's happening in homeowners associations. How do you protect yourself when you may be very conservative or against somebody else's views, whether it's conservative or not conservative, I guess liberal, if you hurt somebody that comes onto your property, or you may get in trouble with your homeowners association. It's maybe a civil issue if you post signs and they say you can't because your covenants prohibited that. That's where we're at right now. In several homeowners associations where we have property, it's come up that other owners want to post signs. One of them because they were almost robbed during this pandemic. Another one in where I'm a board member said that her husband has threatened to kill her. She wants to post no trespass signs. In other instances, we have developers coming in all over the place now. Particularly right now, developers' stock is skyrocketing because there's a lot more people that need work building, so they've got their labor to build, and the interest rates are low. So a lot of people are buying houses, and what does that mean? Those trees are coming down, and people that at one time bordered lakes, forests, they had their privacy, they suddenly don't, and it's creating an ire that wasn't there before. And so what are your rights? Can you stand your ground? Well, that's what we're talking about today. Stand your ground, homeowner association, stand your ground on private property. What are your rights? And I think the golden rule, we'll recap this at the end of our show today, is you need to be reasonable. Don't get hot-headed. Don't go running out there. Because we were just talking about something right before we were on the air today. And what were you saying? You had someone that called you about there was a lake.
Well, it was the same sort of thing. There was an easement. There was an embankment that
Is this in Montgomery or
the Mud District had built. It's Montgomery County, and it backed up to this lake. There were like 10 homes around this lake, and so they start fighting over the trees on a property line, and whether they're on his property line or the homeowner's property line.
There's no fence. Because
it was
a whole lake.
There's a wrought iron fence that stops, and then there are trees that go out to this lake. But it was a personal injury case, though, because the
But tell me this,
individual got hurt.
it kind of confused me a little bit. The wrought iron fence, how tall was it?
It was about 4 feet tall.
Okay. And was the wrought iron fence, was it on the property line or was it on outside the property line?
I think it was on the property line.
Of the man that was unhappy?
The one whose trees were
So we
getting
believe,
chopped down.
but there's a question. Fences don't have to be on property lines. A lot of people put their fences on the other side of the easement because they know that the easement's going to be used, and they want people by the public, for sewage or electric or whatever, and they want people to trespass onto their property inside the easement. And so you don't know if a fence is on someone's property or not. And easement or not, usually an easement's only for the government to be able to trespass upon, depending on how it's structured when it's created. But it's not for your neighbors to come walking along in your backyard inside an easement, or for that matter, the homeowner association. Those people, homeowners representative of the association can't come walking on your easement. They're not allowed to do that. The easement is for utilities, but I can't say that for sure because I don't know what the provisions are in everybody's contract. So your covenants will rule it with regard to whether or not that's an issue. But that's not our issue today. Our issue today is whether or not you can put no trespass signs up on your property if your homeowners association doesn't allow you to do that or doesn't permit it in the covenants. Okay, so now, in order to know that, you need to know what the trespassing signs are in Texas. We went over that briefly, and we had some questions about that. And I'm going to because it's relevant to our discussion. You need to know what criminal trespass is. So in Texas, a person commits a criminal trespass if he entered someone else's property without that person's permission, having received notice that the entry is forbidden. The last part of this definition is important. It's there to prevent an accidental trespasser from being criminalized, such as when an innocent hiker strays off the path and onto someone's private land. If there's no warning, the trespasser cannot be accused of committing a crime. That happens a lot because you may think, particularly like if you're talking about the state forest over here. What is it called? The
BLM.
The BLM.
Yeah.
The state forest off of 1488 and 45. Goodrich used to be the Goodrich, now it's the A&M, whatever it is. It's the state forest. If there's no fences against the properties that back to that, and you could very easily believe that it's on the state property. You would hope the state would say this is where our property ends, but not necessarily, because this is still kind of rural in a lot of places. So if there is no fence, and now we're having all this new development, then you're now opened up to trespassers because your fence used to be your trees, or used to be a lake, or used to be a lot of things, and that kind of goes toward another issue that was in a case that I was just reading about this in Texas, and it was where an elderly couple had lived in a house for many years, 50 years, and the property behind their house was being developed, so all the trees came down, and they were close enough to a main thoroughfare that they were now exposed but it was so new that they were exposed and they had no protection. But they weren't worried because they felt like, well, we don't have to put a fence
Been
up
here
yet.
for 50 years.
You know, we're in our close to our 80s, and you know, certainly they're going to put a fence up. You know, but not necessarily because they had a natural fence line before. And so what happened was a person came onto their property on a bike. And they were just out in their backyard drinking coffee, enjoying their backyard and their serenity, and said, "Hey, I'm one of your neighbors, and my wife needs to go to the hospital. Can I borrow $35 to get her to the hospital? I need cash." And that's a very odd request. I mean, come up with a better story than that. And so they said, "Well, we don't have $35 in cash on us." They had never met this person before. And so then the guy was persistent. He said, "Well, can I go with you to the ATM? I really need the money." But it could be that his wife really needed to go to the hospital and he was on a bike. I mean, it's kind of tit for tat. You don't know. Well, I don't know the situation. I'm only reading this on a lawsuit. And so they put no trespass signs up now. And their homeowners association said, no, got to take them down. Even though they were threatened, just like our neighbor was threatened, just like the neighbor where I'm at a board is threatened because her husband's going to come onto property where it's estranged. So the law, though, is specific. You've got to put people on notice they can't come on. Now the husband,
that's the problem.
estranged husband knew because there's going to be an order there's a local rule order whenever a divorce is entered in Montgomery County that
those
that
standing orders
that you cannot come on to someone's property. It's their property alone, especially during a nasty divorce. So that person asking the board, can I put a sign up when it's prohibited? That is not necessarily something that should be granted because they've already gotten notice. The person that she's afraid of already said, there's already notice you can't come on. And the sign is only worth as much as the sign itself. It doesn't prohibit them from coming on. It's just a notice. They've already got notice. And so then now you're going back to stand your ground. If this person comes onto your property and they've already got notice they can't come on, then, and you know that their intentions may be malicious, maybe not, maybe they just want to make up, but you've got to use reasonable, you've got to be reasonable if you use deadly force. And this is when people do get injured. And what you were saying with your case was, and I stopped you in the middle, what happened with your case where there was the wrought iron fence?
The mud district, they were working on it's not an embankment, it's, where the big metal ridge thing where they put it up and then they fill it in with dirt.
Yes.
It's not an embankment.
Bulkhead, maybe?
Bulkhead, that's what it is, yeah. So they were working on that, but they were digging where the easement was, which was right up to the fence line where that wrought iron fence was.
Okay.
A big ditch, a huge ditch.
Why were they digging a ditch?
I don't know.
Okay.
But he saw them chopping down, or this person saw them chopping down his trees.
Or he believed they were his trees.
And, well, they had gone back and forth and back and forth and back and forth about this, fighting over the trees.
If it was on either, depending on which side the fence was, because the fence may not have been on the property line.
Yeah. And so what happened was he saw them, started running towards them, didn't see the ditch, I guess because he was so upset, and they had just dug it, and falls into
that
this
purpose.
ditch, to make him fall. And he reaches up and he grabs this wrought iron fence, and then he
How old
breaks
is this
his
guy? Any idea?
tendon. He's about 72.
Oh my gosh.
Yeah.
That's Superman.
Yeah, really good shape. Yeah, and actually breaks his tendon and really messes up his arm.
And he wanted to know if he had a case against
So
the-
it was a personal injury case, but that happened on property, and then you get into all the immunity and all of that kind
was
of
there
stuff.
trespass and if there was injury.
Exactly.
And,
How did it exactly
And then we were just
happen?
discussing, because it had nothing to do with the show, but it was kind of something you have to think about. Government entities have governmental immunity, and there's only certain ways that you can sue them for personal injury if something like that occurs. And so it's a little different if you've got a private developer versus or a private neighbor against you. That's a little bit different, but when you go up against the government, I mean, that is more than the 5,000-pound gorilla. That's like, just like we've had in other shows, that's like going up against CPS. It's like, it's just really, really difficult to win under those circumstances. But anyway, so that goes toward, though, it kind of goes toward no trespass signs, because we really don't know if his fence was on the right place. And if the fence was within his property and he had no trespass on maybe a post that was on that side, now that'd be a little bit different, because there may be some liability there, because he would have designated that this was his property and they're coming on and taking his trees down. You can't take someone's trees down. I mean, that's an injury to their property, and there's trees are costly. And then you have to get they have them over here. I think Burdett does it. You have to get an expert that shows what the value of the trees were and how old they were and what it is to replace them and replant them and all that stuff. So anyway, what constitutes notice of trespass? That's what we're talking about today. As to how a trespasser is given notice, this depends on the type of property in question. Generally, a Texas landowner can give notice in one of 4 ways. And this is where we ended last week because we couldn't get past this because we're always talking about something. By telling the trespasser to get off the private land. First is
just verbally,
but you have to see them to do it, and a lot of times you don't see it. You see the remnants of a beer can, or you see footprints in the dirt, or whatever. You don't see who the trespasser is. So then that's when you put your video up, your security cameras. If you have and they're really cheap these days. If you can get a feed, you can do one. They can be wireless, and you can put them right to your phone. So that's the first thing. Is if that's to me that's reasonable. If you think there's somebody trespassing your land,
verbal first.
Well, first verbal, if you can catch them. If you can't catch them, to tell them verbally, maybe you can find out who they are if you put your video camera up there.
Okay.
You're not hurt. You can find, you don't have to be yelling at your neighbors. You think it's them. You can first do the reasonable thing, find out who it is, okay, if you think it's a continuing thing. The second way is by erecting fencing around the land that's obviously designed to keep intruders out. Many people have fences, but there's no law that you have to have a fence around your property. And but you can go so far as just having 2 barbed wires, just enough to make it evident. This is a fence. This isn't a pretty little garden. This is a fence, and you're not supposed to trespass into this, right? The third way is something that I didn't know, but it's an old Texas law, and it's by placing purple paint marks on posts or trees on the property, on the borders. And the purple paint trespass warnings carry the same weight as a traditional, quote, no trespassing sign. Okay. They must be vertical lines at least 8 inches long, so up and down 8 inches long, and 1 inch wide, situated about at eye level. Okay. So it's about the size of a ruler, 3/4 of an inch of a ruler, and at eye level, between 3 and 5 feet off the ground. Well, I think you're a midget if that's eye level, honestly. I don't know where they're coming up with that in the law. But they must be placed at easily seen locations no more than 1,000 feet apart on forest land, which we have a lot of out here in Montgomery County, or 1,000 feet apart on other on other properties. So even if it's not forest land. And the law is designed to spare rural landowners from having to continually replace signs that end up being stolen, overgrown with foliage, or damaged by the elements. So, because they fall off. I mean, you nail them on and they get faded or they fall off. And so this is your opportunity to do that. But really, as a kid trespassing is not going to know that a purple line means anything.
Tony, I didn't know until you told me that a couple of days ago.
And it really won't work out I think we're really rural. We're not really rural out here in Montgomery County so much anymore. Many, many people have tracts of land that are between, let's say, 1 and 20 acres, which is still a large tract of land that may have forest that surrounds it. And that seems kind of far-fetched that you're going to go out and paint your 10-acre tract or, even your 20-acre tract with this purple, if you didn't even know it. Because you and I are attorneys and we didn't know that.
No, right.
But it is a defense against somebody that trespasses on your land if you didn't have that.
Yeah.
They didn't have any no trespass signs, no fence, no purple, no, if they're really looking into it. Because criminals know the law better than people that don't break the law.
That's true.
So that means that they would be willing to look at this, say, oh, look, this is it, I can go on here. So be aware, criminals know the law. The jailhouse lawyers, they have a lot of time sitting in there while they're thinking about it. And a lot of them don't learn their lesson. They come back out and they're thinking, what's a good way that I can get reparations?
I won't get in trouble again.
Yeah. Maybe I don't fall into any reparation law, but I'm going to find a way to make things right. Maybe it's a Hatfield McCoy kind of thing, which went on for, a century before they finally buried the hatchet. Some types of land do not need a warning system. For instance, if the land is obviously being used to grow, cultivate, or harvest crops, any intruder is deemed to have noticed that the land is private property and they shouldn't be intruding. So if you've got your zip line up, or if you're growing tomatoes and or you've got your little garden going, they should know that that's not just land. But we were out in Grimes County for a funeral a few weeks ago.
Where is Grimes County?
It is. It borders Montgomery.
Okay.
Grimes County has. I'm trying to think of the county seat is. it's not Shiloh, it's Anderson. But if you're going down 105 toward A&M, that's the way everybody. If you're in Conroe and you're going to A&M, more than likely you're going to go up 45 and get to 105, or you're going to go up 105, or you're going to go to 2874, or to the Renaissance Festival, you're going to get to Grimes County.
Okay.
You're going towards Stoneham and Navasota. Navasota, Stoneham. But right there at Highway 6 in 290 is pretty much where Grimes County is. And so I went up there, and it's like an area where there's still a lot of rural tree land up there. Just like in San Jacinto, just like in, even where Montgomery County Show, just a lot of our areas up here are still very treed. And they're owned by somebody, we don't know who, but they don't necessarily look like they're owned by anybody. They're they're just treed land that somebody owns, and maybe they're keeping it for forest. Maybe they're keeping it for whatever. Maybe it's, who knows why they've got it. Maybe oil and gas land, and an oil and gas company owns it. But if there's no evidence that you can't trespass, it could very well be state or federal. Like we've got our they're not federal. What do they call the parks that are federal parks? You have state parks, and then you have, what's the other? The parks like Yosemite. It's not a state park. They're
national parks.
National. Thank you. They're not federal. I was thinking
it's national.
Federal sounds so scary. Anyway, Texas no trespassing notices. Compared to those of other states, Texas is not too prescriptive when it comes to posting no trespassing signs. There is no requirement to have the sign professionally made. There are no size, color, or font requirements. The state does not dictate the size, the sign, or even where it should be posted. So in order to comply with telling people to not trespass, they don't tell you what to do. They say you have to post it. It has to look like you're using your property, or have to have the purple line. But the sign, if you want to go that direction, they're saying there's no rules. It could be as big as a billboard, or it could be as tiny as a thimble, from what this is saying. But it has to give them notice. So the only requirements, of course, I'm answering my own question. The only requirements that the sign is clearly indicated to keep intruders out, and it's placed somewhere an intruder is reasonably likely to see. In other words, a legible sign that contains the words "no trespassing, private property, do not enter," or similar language placed at the entrance to a property, or even at reasonable intervals around the property perimeter, should do the trick. All right. So if you have a no trespassing sign, intruders will be shot. That's sufficient because you're giving them notice. But if that very trespasser has got notice because there was an order that says you can't come on, even if there's nothing else, then that's notice, that's legal notice. And so they can't say, well, I didn't see it on the property. Not receiving adequate notice is a defense to criminal trespass. So if a trespasser can show the warning sign had fallen down, was illegible, broken, or weather-beaten, covered by tree branches, or there simply weren't enough signs, for example, there was a sign at the front of the property, but the trespasser intruded through the back, then he may be able to escape criminal trespass conviction. Even if it's coming in to do no good. If you can't prove he was coming in to do no good, then he can trespass and get away with it, which is really bad. Bad guys getting away with a bad act. It's up to the landowner to ensure the signage meets the legal requirements and is sufficient to warn off anyone attempting to enter the property. All right. There's legal no trespassing signs in different states, and we just went over the ones in Texas. But what we were going to go over now is what your rights are for a homeowners association, because homeowner associations and almost all the covenants that I've read, we're talking about River Oaks, and those homeowner associations were created back in the 1920s. I mean, right when I want to say 20s, I want to say 40s. I think River Oaks may have started in the 20s, but the 40s was when everyone was coming home from World War II, and they started putting in subdivisions, the Pottersvilles.
Right.
And they created these little, small, democratic societies that were not paid of people that should govern themselves, which goes back to why we even have a government in the United States. Our government was a governing body with George Washington and the group coming over saying, let's set up a group of people because they're too harsh and they won't let us have our religious liberties, and they're overtaxing us, and they're just hard over there in France and England, and people were starving while the rich were literally lavishly getting richer during the times of Marie Antoinette and what have you.
And people were being sent to debtors' prisons.
And they were being sent to prison just like in Les Miserables by Victor Hugo. We just watched that movie.
Yeah,
they were
that's
being sent to prison for giving bread to relatives. I mean, it was really harsh. So during that exact period in the early 1800s, late 1700s, early 1800s, people were like, put me on a ship. I'll take the Indians over this anytime. And so they were coming over, and they were a hardy group. They came over and they established a very good Declaration of Independence, and very wise, educated people did this. And the reason that they gave us they let us govern ourselves the way they did, and I was listening to this by our Attorney General, William Barr, was kind of giving a speech at Notre Dame, and I was listening on the YouTube, and it was so fascinating.
Yeah.
He said that a big part of the reason that we had so much autonomy to have these three branches of government that let ourselves self-govern with right to arms, and they didn't even want the Bill of Rights that had the Second Amendment rights, because they felt like what they had was enough, because they believed that if people followed the religion that was in the Bible, whether you're Jewish or whatever, it gave us a standard, the Ten Commandments, and rules to live by. These were religious people coming over to escape persecution of religion. They would govern themselves under God's law.
Right.
And then what happens, you get all these people that were doing just the opposite right now, where they're saying
So
they
true.
don't want any religion in the schools.
I was talking to my daughter about
like
this very thing.
Crazy.
Mm-hmm.
That what the people now that are being bullied are the ones that are saying, we just want to be able to pray. It's our right.
I know.
Silent prayer at a football game.
Mm-hmm.
And now the people are saying, no, you're violating our religious right not to have it. No, that's not what our laws were. Our laws were.
They weren't written for that group of people.
They weren't written for people to oppose it.
Right.
You can't do it. They were written for the people to allow them to have it.
I know.
Completely understand it. It's not a religion to say there's no religion. So, but I'm getting off the beaten track on that. That has to do with these signs, and why the small democratic group that we have as our homeowners associations, they get a little crazy. They're usually retired people, maybe not always, but sometimes they get the power and they kind of go with it. I'm on board. I see both sides of it. But on the other hand, homeowner associations are trying to do the best they can until they get power hungry.
Well, they're supposed to, Tony. You and I have talked about that a ton. They're supposed to be protecting the value of the property.
Right. That's the major tenet is you're protecting the value of the property. So the homeowners association, their property values won't go lower, right? Mm-hmm. And that's it. That's really all they're trying to do. Is as a group, you're saying we need to protect our property, so you don't have somebody coming in there and putting building a gas station on the corner that's going to be against the covenants and the various levels.
Or chicken coop by the street or
So,
whatever.
and it's all trashy. They're just trying to say you can't do that unless it's already trashy, and then why not? Right.
Right.
So, but
it's protect the value, whatever the value is, and whatever
it is.
Neighborhood
but you're not supposed
in.
to go in there as a homeowner association and say we're going to increase the value, and so we're going to assess everybody. That's wrong.
And we're not going to let you do anything that you feel like you need to do.
But at the same time, if the climate of the community has changed over time,
right,
then you've kind of waived it, and so there's some argument. And so what happens is you get these new elected board members, unless they're like, I say to say like ours, where the same ones keep being reelected, and then you've got like a dictatorship for the last 20 or 30 years of however long, because they won't come off. But when you get the flip side of that, if you get somebody new every 3 years, then you don't know you have a continuum, and so you don't know how they're ruling. I think fresh blood is good. That's why that they put in our Constitution that you only can have the same president, elected twice, no more. I think that there was a reason for that.
That's not in our Constitution. Was that amended?
It's in the Bill of Rights, yes. It's in the amendments.
It was an
not
amendment.
Bill of Rights.
That was
10.
after FDR.
It was like, I think, number 27.
Yeah.
It's, you can't be elected, after FDR.
Mm-hmm.
You can only have a 2-term limit, whether it's together or separate, 2-term limit for presidents. I think they need that for homeowners associations.
I do too.
And I'm a board member.
I think they
that.
need it for senators and congressmen too.
First of all, it's exhausting being a board member because you get beat down on, and if you get people that are stuck in there and it becomes a dictatorship, that's wrong too.
Right.
Because then you've got everybody afraid to deny
level.
you because it's like Napoleon or like Santa Anna. It's like you deny me, I'm going to cut your head off. And then you've alienated your entire home. So, but here's going back to signs. Here's the answer. If you're homeowners, if you have to go to your covenants, there's no statute that protects you. You've got a statute that says you can have political signs within 90 days. There's some, you have to go, I think we talked about that in Texas Property Code 202.
Within 90 days of the election?
Yeah, you can post and it gives you a size. You can only, I think there's a limit to them also. But go look that up. We're not talking about that today. But political signs, to some degree, you can have them up for a limited period of time, right? And then you can have religious, during the religious season, there's certain periods of time where on your front door, and there's some rules against that. They have a statute that says you're allowed, your homeowner association can't have any provision, or it's void, that won't allow you some religious expression, right? And I wish I could remember the political sign rule, but I believe it's 90 days, and you can't have 1 million of them. It can only be, but you may be able to. different story. We'll get over that. We'll talk about that later. But political signs you can have subject to the statutes. Religious signs and expression you can have subject to statute. Most homeowner associations will have written into their provisions that you can have a for sale sign that's a certain level. But almost none of them allow a no trespass sign that I've seen exposure to, starting from River Oaks, Grand Lakes, Westwood, all the different communities on up.
Really?
Yeah, I haven't seen that. So typically, only signs allowed in an HOA are, and if you have to look at your covenants for this specifically, and you can download them and do a little search where you can read it and just look for the word sign if you want to do that, or ask your management company to get paid pretty good for looking for stuff like this. Typically, only signs allowed in HOA are, quote, for sale or for rent signs. A no trespassing sign, honestly, I'm reading this off of another attorney's dialogue here. A no trespassing sign, in quote, holds no power. It's just a sign to make you feel better. Instead, you need to do the research on the laws backing up having one of those signs. Some states, no trespassing signs don't make any more stronger punishment than any other piece of property, which is not the case here. The matter of fact, private property signs probably have a similar meaning, but you can't, if it says you can have only for sale signs, you can't have a private property sign either in Texas. So you're limited.
So if you can have only for sale signs, you cannot have private property?
Right, unless it's a political sign or it may be a sign for your religious expression. And those were exceptions that were put into the statute. I believe it was 2011. But before that, you couldn't have those signs either. But what happens is homeowners associations, if they become unenforceable if you were to sue each other, which is a very costly thing too. Because if you've got a provision that doesn't allow you to have a sign, but everyone is doing it, then it's waived if a certain number of persons have been allowed to do that. And particularly if you've been doing it for 4 years, there's like a statute of limitations where they can't ask you to bring it down now if it was discoverable. So there's some issues with it if it's been done in your community or something's been done in your community for a long time and 4 years have passed and whatever it was obvious, then you can't now say because you no longer have the, again, statute of limitations to argue about it. And so the homeowner association has to back off. Now, the reason I'm only bringing this up is because, well, not the only reason, but if the homeowner association sues you because you're breaching a covenant to take your signs down and you're going to say, no, during this pandemic, I'm not going to do that, you can just sue me. The problem you have is if they win in court because the covenants prevail, because it hasn't been over 4 years, it's unambiguous, it's very clear. You signed when you bought your house, that covenant was a part of a rule that ran with the land that you were subject to. Normally, you always sign off in a closing. If you don't, it's in the public record, so you can't get by with saying you didn't know, saying what the rules are. You signed agreeing to those rules. And so short of you going to the homeowners association asking for them to change it with a bunch of people signing off, whatever your rules are, if there aren't any rules, it's 67% of the people, whatever the rules are to vote, that you change the amendment, then they'll win, and they get their attorney's fees if they sue you if they want to go that far. What the issue here is, why would the homeowner association sue you for putting a trespassing sign up if you were just, almost robbed? And and the law says if you don't notice somebody that you can't come in because you don't have a fence, you don't have any place. The purple notices are not. You're not on rural property. You only have like 5 acres, and you can see the house, your mansion from the street. Then why?
Well, so why would they?
You would think they wouldn't.
They're just bullies.
But right now, our homeowner association, to me, I'm not involved in the two entities involved, except for I'm watching the homeowner association meeting through Zoom because everyone knows, or if you don't know this, typically members cannot speak unless it's the annual meeting. So all you can do is just contact your homeowner association, but they'll come after you. And, the deed restriction Gestapo will send you a letter through their management company saying you can't do this. And if you do, I'll give you 3 notices and now I'm going to fine you, which is just building the till of money from a bunch of, somewhat rich people because they're homeowners. So none of it's all crazy. You would think that they would say you're helping the community by letting trespassers know they're not going to get away with this. The alternative would be for them to mitigate because they have a duty to keep you safe and put in the front of the homeowners association a sign saying, no trespassers. Now that I've seen in many gated communities, and we don't have a gated community, but that is a way that they can be sued for not protecting you if you get hurt. So that's an alternative. Still, if you at the back of your property is not at the entrance and it's forested like a lot of our property is, why can't you put a no trespass sign? So it's still sort of like you are the homeowner association's here to protect me, but you're not protecting me. So I would think that would be probably a draw, and it's a lot of money to go to court. because now if you're not an attorney, or if you want to go to court and waste and put that much anxiety on your life over something like this,
Yeah, no
then do it. That's
kidding.
why there's not a lot of cases about that. So anyway, some people are talking about in this case. It says they had a sign at the front entrance that said no solicitation, and they're saying that if we could legally enforce kicking out solicitors, that's another issue, because you also have a right as a citizen of the United States in Texas, and maybe even a member of your community to what is that? The right to, it's not the Second Amendment, the Fourth Amendment. Which amendment is it? You have a right to freely, I think it's the First Amendment.
Associate?
Yeah, freely associate. So you can go to someone's door, and so maybe you don't want somebody to come solicit. Well, if that's not a part of your covenant rules, your neighbors can come solicit, and if you tell them to go away, and they don't go away, they're trespassing. But there's no rules in any of the homeowner associations I've seen that says no solicitation. You should be able to go talk to your neighbor. And what happened with me when I was going to get signatures with my own personal experience for a deed restriction amendment, doing it the right way, told by the homeowners association board and management company, you need to go get a signatures if you want this to be presented or to get it passed. And we had both ways to do it, which I did. And so I was greeted with open arms by most of my community. But then I had like one person out of the entire people in 100 people in our community saying, "Get off my property." And I was scared to death because I'd never met him before. And I was like, like you would not believe.
What did he do? Just yell at you?
Yeah, and I was doing actually a service. They were told me in the community to go get drainage information. And so I was doing it. It was twofold. I was getting drainage information to find out if they had any issues, so I could, because you can't see on their property. And he ran me off, and I never went back on his property again because he said, "No, don't trespass." And I was like, "I'm out of here." And you would not have believed somebody at my age could run as fast as I did, but I did. And through the trees and the whole thing. And so anyway,
gosh.
but if you want to get that changed and it's not in your rules, then that's the same way. You'd have to go get that. You'd have to get an amendment to change that. Now, there are laws that do not require people to have actual licenses to solicit. In Texas, you don't need a license for that, which means we cannot stop them. And so you can't stop them, and so you have to have this issue. I think it's best if you have a gated community, you keep your gate locked, you've got a buzzer, but you can't put any signs up. You can't even say, "Don't enter" without buzzing or whatever. It's the craziest thing. Most homeowner associations are not nasty about that, though, and they'll let you, they're not going to enforce something of that nature if it's small and its purpose shows what it's service. So you have to be reasonable about in life, reasonable.
No kidding.
Why not instead consider you all organize a neighborhood watch program? That's one other alternative if you want to do that. We do have security in one of our other homeowners associations. We pay a security guard to travel around.
Yeah.
And then you can ask him to leave, or you can get their attention. You do not want to tie in the HOA with the neighborhood watch except for its approval to exist, which is not true. We had a neighborhood watch program, and they got together and said, "Hey, we put our money in for our assessments every year. We think we can afford a neighborhood security." We have it. It works out really well.
Well, why is there suggestion
Not where I live, but another place
not to intertwine or
I
intermingle
think
the
because,
two? I wonder.
I have no idea, except for here, maybe they're just thinking that members are being pushy. Hard to
Oh,
say.
yeah.
Otherwise, it's a separate entity that works with the police who do have the power. Oh, that's what they're saying. The answer to your question. Otherwise, it is a separate entity that works with the police who do have the power to do something legally. So I guess our security guard has the authority to go on property. But I can tell you right now, in the homeowner association where we have security, he just patrols the area. I don't see. We've never had one complaint for the number of years, and it's been about 20 since we've owned that property. Never once has something come up where security was crazy, except some people where he told them you can't be, shooting fireworks on the tennis court and destroying the association property. So that's kind of where it went with that. All right, so I'm going to let you ask us some questions that we have about homeowners association, and we've got the answers to that some of our listeners have come up with. And then I've got some listener questions that are pinging me. So while you're doing that, I'm going to look real quick.
Okay. How are homeowners associations in Texas governed in general? Well, I mean,
That's
there's
the Texas property
statute,
code. Yeah,
right?
Texas property code.
They're
So
governed by statute. I think you really have covered that.
yeah, Texas, if you don't know, if your association rules look really crazy to you and you think that you're being railroaded and these assessments that I'm paying are going toward, only creating something that makes the board member's house beautiful or helps them only, then what you need to do is you need to go to your covenants. They are the end all and those are the lowest level of your rules, and they were created by your community or the developer generally, unless the developer didn't create them and you can create them later. A lot of people want to get rid of their HOAs. I think we have some questions about that. Can you get rid of your HOA? In fact, that's a good question on that too. Go to the front where I've got the questions that are listed, and I think some of the questions are: can you get rid of your HOA? What do you do? I forgot what some of them.
Where do they get their authority?
Yeah.
How are they? Let's see, budgetary requirements. How does Texas?
The way they get their authority, though, is the developer sets it up, and then because they own the land first, they have the right to make a restriction in their deed prior to restrict the usage of that property going onto you. And so, and I had another friend of mine that was having an issue with a deed restriction that could not possibly be enforced because it was only between two different owners. But if it runs with the land, then what you have to do is you have to get the other owners. There's an agreement between two people. You have to get the other owner to agree to release that restriction. And what if the other owner doesn't exist anymore? Well, if it runs with the land because it was filed with a deed, then you have to find the descendants of that or the predecessors of the ownership of that property. More than likely, if they're not there, they are not going to care. But if the deed restriction ran with the land for the person that owns it now, that's more than likely who you're going to have to go to. And if it's reasonable, if you want to pay them a little something, work some kind of deal out with them, they'll probably release it. I don't know. Every different situation is unique. But the way it generally works is a developer comes in, just like they did in 1836. You can consider them the first developers. Stephen F. Austin's colony came in here and started, getting tons of land. They go in, they say, I'm going to buy this land, I'm going to develop it, do whatever they're going to do. And they make, in order that they can sell it, to make it to be attractive, they said, just like they did in River Oaks in the 1920s or 40s, and I can't remember which year it was, which decade, they said these are the things that are going to rule this land, and your neighbor can't put a pig pen in, and they can't have a gas station next to them, and those run with the land. And so you go to those covenants, no matter how old they are, to see what your rules are. And what happens a lot of times, these covenants are no longer valid because it says you can't chain a horse up to the post outside your property. No one has horses that they're using for transportation anymore. Although we're a ranch community and we have horses, if there was a covenant that said that, it probably it may or may not apply anymore. And of course, I know we don't have those. But the River Oaks provisions are what made River Oaks the community it is now, because everybody wanted to live in a community that had all these restrictions that your neighbor couldn't do something crazy. And they are still fighting it out and dogging it out over rules that are, almost 80 years old because they still apply.
Well, here's a question. What can homeowners do if an HOA is not responsive to complaints? So, I'm thinking this neighbor's got this no trespassing sign up. The HOA says it's supposed to come down. And
here's a better one that just came up. We have a neighbor in our community right now. This came up this morning that said, hey, what do I do? The guy behind me, the neighbor that backs to me, is filling in the drainage easement. And because he wants to sell his property and he wants to show he has more property back there. And she said, that's not right because my fence is outside of it borders my easement and not my property line. And his fence is on the property line. So it looks like there's an easement where her land is. But now he's coming in and, of course, it's behind a metal fence. But he's coming in and he's filling in a massive ditch.
Behind his fence.
And so what do our deed restrictions say? There's nothing that says in that landowners association, there's nothing to say that if the other easements are being clogged right now, and so it's a dry ditch, but if they were being used properly and the county was responsible, as they say they are, for coming in and cleaning out the ditch, there would be a drainage easement and the whole community would be in a better place. The county is supposed to come in and dig those ditches out. So why is it the county coming in and creating the drainage, alleviating the drainage issue that they're responsible for by coming in? Well, they never have, and people have put fences in there and they're clogged and they're not. They can come. You can call them and they'll come in. But if your next door neighbor is now the next clog, then that neighbor behind them has got to call them. And so you're kind of watching each other. And so what's happening is this owner is filling it in, and she's asking us, what do I do? Well, our covenants don't protect her the law has to protect her. So she has to go the next step up, which is a statute. So the question is, can the homeowners association come in? Only if the covenants, which is all the homeowners association can comply with, say that they have a responsibility. The next step up is the county. And so she may need to go to the county and say, I'm going to sue the county if you don't take care of me. Maybe the county didn't have any responsibility. Then you go to the state. Natural drainage easements through the state. The state also has a responsibility to make sure that you're not flooded by what somebody else's does if there's a natural drainage easement. There's a bunch of different laws on it. Texas A&M's real estate site has a lot of articles on it that are very, very good. But it goes toward. But let's say that your home association is responsible. Okay. So what does it say that you do if your home association should do something and they don't?
Well, be reasonable, try and resolve things by talking, using the association's democratic processes. Under Texas law, members of an HOA have a right to attend board meetings.
But not
and
under
be
Texas
heard.
law. They get, if your association allows like a 3-minute, for them to speak, they can. But the Zoom meetings, those monthly meetings, the members, and this is in the statute, can't talk. Only place it's a members meeting, an annual meeting. Then you can talk and go crazy, and no one shows up for them practically.
Well, this is meetings and to be heard at regular member meetings.
Okay.
Under Texas law, that's Texas Property Code 209.0051.
So it actually does say 0051 that they can be heard at regular
meetings.
Okay. I may stand corrected on that because my understanding was Texas Property Code 209.0051 only allowed members to speak at the meetings they were allowed to speak at, which was the member meeting. I mean, the annual meetings.
Well, that's not what this says. So
Okay.
I don't know
I'll
if
look
this
that
is
up.
correct.
I'm going to correct myself on the next show if I'm wrong.
It's generally a good idea to keep records of any written communications, blah, blah, blah. If a board member is abusing power or acting unfairly, members can try to elect someone else for the next term. Texas law prohibits HOAs from restricting a member's right to run for a position on the board. So a dissatisfied member always has the option of running for the board, him or herself, and many associations allow for the removal or recall of board members, sometimes for cause and sometimes not.
It's very expensive to do that. So I've been involved in some lawsuits, not personally, but helping some attorneys as co-counsel. Very, very expensive and almost impossible to get done.
To remove a board member?
Remove a board member or a whole board. It's very difficult.
Really? Okay, well, so Tony, it looks like we're out of time. We want to thank you guys for listening and remind you to
serve God by serving others.
So we'll see you next week, guys.
Today's show was recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and all rights and ownership are reserved to Lone Star Community Radio. For more information regarding this program and Lone Star Community Radio, visit us online at irlonestar.com. Lone Star Community Radio is Montgomery County's community radio station, serving the community with local programming on TV, radio, and online. If you enjoyed today's program, please support us by sponsorship or starting your own show. Contact us today by phone or text at 936-666-1084 or email the station at lscrstudios@gmail.com.